I'm Ken Carlson. I've been an attorney specializing in landlord-tenant law since 1980. This is the next in a series about your rights as a tenant, brought to you by the caltenantlaw.com website. In this video, we're looking at how you get your security deposit back. Landlords love to steal tenants' security deposits using all kinds of fraud and bullying. Civil Code Section 1950.5, the law which governs security deposits, goes on for 3 pages trying to protect tenants from all the ways the landlords have tried to steal it. Among all the laws that protect tenants, a security deposit has the best protections, but the landlords still think they can get away with stealing it. Embezzlement and fraud are the criminal terms, both felonies, but the courts let landlords get away with it. Obviously, you're a victim of this, or suspect that you soon will be, which is why you're watching this. A security deposit has a legitimate purpose. It's your money, held by the landlord in trust to cover any unpaid rent, physical damage to the property, cleaning, or replacement of items. No part of it can be made non-refundable. The maximum deposit is 2 months' rent for an unfurnished place and 3 months' rent for a fully furnished place. If the rent is increased, the deposit can also be increased within those limits. It includes pet and key deposits, cleaning fees, advance payment of rent like a last month's rent, and preparation charges. Regardless of the name, if it is to cover your breach of the rental agreement, it is part of the security deposit. When you leave, the landlord can apply it only to legitimate charges and must give you back the rest of it with an accounting of where the money went. Seems simple enough until you see what landlords do to try to steal it. You have the right to a preliminary inspection, in addition to the final inspection after you leave. The landlord looks for any possible deductions for damage, cleaning, or missing items, and gives you a written list of his proposed deductions. It has to be during the last couple of weeks that you will be there, so that you have enough time to clean and make repairs. The idea is that you would be able to make those repairs so that the landlord gets the property back in good shape and you get your entire security deposit back. 48 hours notice in advance is required for the landlord to come in, but you can agree to less notice. It can be at a mutually agreed time or not, and it is one of the few reasons that the landlord can enter the property if you requested the inspection. Except if you're being evicted by one of the 3-day notice reasons like non-payment of rent, breach of the lease, nuisance, subleasing, the landlord is required to tell you about this right and the right to be present for the inspection. You can refuse it, but you should ask him to do it for your own protection. Even if you're breaking the lease, the landlord still has to give you this right. If the landlord doesn't tell you, you should tell the landlord that you want it done. The written list is important for 2 reasons. The first reason is that the landlord cannot take deductions from your deposit after you leave if that item was not included in this preliminary inspection list. There are only 2 exceptions to that. One exception is if your personal property hid the damage. For example, if you put a sledgehammer hole in the wall and covered it up with a picture, or you hid a stain on the carpet with a throw rug. But if the defect was not hidden and the landlord just missed it, the deduction for it that the landlord discovered after you leave is illegal. That prevents any surprises. The other exception is where the damage was caused after the inspection, but before you finished moving, such as the furniture movers putting a dent in the wall. The second reason is to give you not just a chance to fix the items, but to take pictures and get proof that you did not cause a defect on the list. It used to be commonplace for landlords to tell you everything looks fine, but when you finish moving, claim that you trashed the place, making up all kinds of wild stories to steal your deposit. This list prevents that mostly because you can focus your proof on the listed items from the preliminary inspection. It's usually cheaper for you to make the repair and clean than to trust the landlord, who probably pads the bill to pocket extra money. You could fix the item yourself, hire a handyman, hire a cleaning company, and save money. You can replace carpet for less than the landlord would charge, even if they tell you that you can't do it. The landlord wants to charge you not just to replace it, but for the more expensive version, upgrading the unit so they can jack up the rent even higher for the new tenant. Landlords may say that you have to hand them the keys and other conditions for you to move out. Not so. You leave the keys, garage opener, etc. on the kitchen counter, take a picture of it, and lock the doors. You call the landlord and tell them that's where they are. Otherwise, landlords will make themselves scarce, claiming that you owe the rent until you finally catch up with them and hand them the keys. It happens all the time. Also, it's a good idea to take pictures of the entire unit before you leave to show how you left it and to identify any possible problem that you had in the unit. A picture from one corner of each room and from the opposite corner gives a full view of the room. A picture of each item that might be listed by the landlord and of each thing that was a problem for you during your stay would be a good idea. For example, a picture of the broken handle, the window that won't close, the slow drainage, the electrical outlet that didn't work, and so forth. A picture is worth more than 1,000 words. If the landlord claims that you trashed the place, you show the judge these pictures, taken on your last day, proving that your landlord is a liar. You will have things that you aren't taking with you. It's best to put them in the trash and not leave them in the unit where a judge could see that you left the place in bad shape from that. If there are things that aren't trash, like old furniture that you aren't keeping, you can simply put it in your parking space or somewhere outside or have a garage giveaway sale. You want to make sure that your landlord has a mailing address for the deposit, like by a letter or email that you can keep a copy of. If the landlord did not do the preliminary inspection, you also want to put that in the letter, expressly saying that you found out that the landlord was supposed to do this, and they didn't. So they can't deduct anything from the deposit for cleaning and repairs. Turn off all the utilities in your name. His workers are not going to have you pay their electricity, heat, and other features they use after you're there. Also, file your forwarding address with the post office and reset all your regular contacts like banks, schools, services, and work-related centers. Whatever the deductions are, the amounts have to be reasonable, and the landlord has to prove that. If it's just your word against his, you win. Actually, it's easy for you to show what a thing or service costs, like finding it online, to put you on top of that debate. The landlord can deduct for unpaid rent, but not for rental damages, meaning the daily value of the place after the lease or notice ends. It can't be used for late fees, attorney fees, court filing fees, or other money charges. If there is a dispute about unpaid rent, such as the amount or whether it was even due, the landlord has to prove it. Again, if it's just your word against his, you win. The second type of deduction permitted from your security deposit is for damage. This is the part that most of the disputes are over, and it's a lot more complicated than the other types of deductions. First of all, the deduction has to be for damage that you caused beyond normal wear and tear. There's no legal definition of wear and tear, and it's more like common sense. You walk on the wooden floors, leaving scuff marks, so does the judge. You put nail holes and screw holes in the walls to hold up pictures and things, so does the judge. You wear down the carpet by walking on it, so does the judge. If it happened in your normal living activity, it's probably normal wear and tear. Next, it has to be actual damage. Landlords commonly charge you for painting, but that is neither repair nor cleaning, so it's not a legal deduction. As a practical matter, the landlord's painter will spackle over holes that the paint won't automatically fill as part of the normal process. If you painted the walls, that is not damage. Or it might be a breach of the lease, like a provision that says you can't paint, and the landlord can separately sue you for that, but he cannot deduct for painting over your paint as a repair of damage. Navajo white is not sacred. Similarly, a lawn that naturally dies is not damage. Living things die. Did you intentionally kill it? No. Another common situation is where you took off something and replaced it with your own, like a lighting fixture, French doors, window blinds, or an appliance. You took his off, put it in the garage or closet, and put on yours. Then when you leave, you take yours off without putting the original one back on. That is not damage. Or you bolt a TV bracket on the wall to hold your 70-inch TV, and you remove it when you leave. You can spackle in the hole, but bolting the bracket on was not damage. Carpet stains can almost always be removed with all the new chemicals. Of course, ask a carpet cleaner, and they say, yes, the stain can be removed. But ask a carpet salesman, and they say, no way, it has to be replaced. Next, the damage has to be something that you caused. If it was broken when you moved in, you didn't cause it. If you turned a faucet that broke off from metal fatigue, you didn't cause it. If a neighbor's baseball broke the window, you didn't cause it. The problem could be caused by a neighbor, like a clogged main sewage line from something that the neighbor did that happened to affect you on the lower floor. Metal fatigue in faucets, leaks in pipes, electrical outlets and switches malfunctioning, the garbage disposal or a dishwasher motor burning out, and many other things may occur, not because of anything unusual that you did, just because of the inevitable breakdown of the item. Slow drainage may be caused by roots or just accumulated grease and dirt that clogs the pipes, not something you did. It's a 2-inch pipe, so what could you possibly have gotten into it, and how? A golf ball could make it through a clean 2-inch pipe. If the leaky roof or a leaky pipe inside the wall resulted in mold, you didn't cause that. A microwave that stops working is not damage that you caused. If you use things normally, not abusively, and they break or stop working, you didn't cause it. Now, let's talk about older things. Depreciation. Consumer items all have a manufacturer's lifespan. For example, a typical apartment carpet has a 10-year life, so if the carpet is 15 years old when you leave and you completely destroyed it, you've only damaged trash. The landlord was going to have to replace it anyway. If the carpet was 9 years old and had a year to go, you owe 1/10 of the replacement cost, not the entire carpet. The same for appliances, which, even if you break them, may already be obsolete and need to be replaced. The next item for deduction from the security deposit is cleaning. Now, if you hired a cleaning person to shampoo the carpet and clean the entire unit, the receipt for that work will convince the judge that you left the place clean. How clean? The law says to the same level of cleanliness it was at the inception of the tenancy, not to operating room sanitary level. If the oven was not cleaned when you moved in, you don't have to clean it when you move out. Same for windows, closets, walls, bathroom, etc. Landlords love to claim that they deep cleaned the unit. But what does that mean? You beat them to it, and you claim that you deep cleaned the unit before you left. If you cleaned it and the landlord re-cleaned it, their cleaning was not necessary, even if they spent $1,000. They can't deduct that cost from your deposit. How are they going to prove that you didn't return it to the level of cleanliness that you got it? It's just your word against his. You win. The The final kind of deduction is for replacements. To use the security deposit to replace things, the rental agreement itself has to specifically permit that, or the deduction is illegal. You might forget to return the garage opener or something simple like that. On a prompt, you could just mail it back to them rather than pay for a new one. You might take the shower or living room curtains, light bulbs, a garden hose, not intentionally, but by people helping you move who thought it was yours. It rarely happens, but it can be a legal deduction. The law says that the landlord has 21 days from the day you left within which to return or account for your deposit. He can mail it, but by the 21st day. That's not the day that the lease ends, that's not the day that the landlord claims you left, or the day that the landlord finally went over to see that you were gone. It's why you want to write a letter to the landlord to say that you left on X date, so you have a starting point for the 21 days. If the landlord does not return or account for the deposit within 21 days, he forfeits the right to deduct anything, even legitimate charges. Of course, he could separately sue you in small claims court for those things, but first he has to give you back your full deposit without any deductions. The law requires the accounting to show the deposit, the listed deductions and corresponding amounts, and the total on the cover sheet. Then, attached to it must be the receipts for the costs listed, like $5.26 from Home Depot for the light switch, and $50 for Joe Handyman to put in the light switch, and so forth. If the landlord spent their own time, the number of hours spent and the rate per hour paid must be separately shown. You compare that new list to the preliminary inspection list to see if there are any new items added, and you ask the landlord how that could be. With the backup paperwork, you can call the company who did the work to confirm the situation. The carpet installer may say that the carpet that was replaced was already past its life, or that the carpet was installed in the landlord's home, or that the new carpet was luxury carpet replacing the cheap apartment carpet you had. The company may not exist, or the receipt is just fake. The work done may have only been described as repairing damage, but in reality was a complete upgrading and remodeling, not legal deductions. Some cities require interest to be paid to the tenant for the security deposit held as well, and that would need to be included. If you paid for a full month, but left mid-month, such as due to habitability defects that the landlord would not fix, the balance of that last month's rent becomes part of your security deposit, because an advance payment of rent is part of the definition of a security deposit. You are required to pay on the first of the month in advance, and without such a requirement, the rent is otherwise due on the last day of the month. So, the question then becomes, what if they don't? This is the fun part, because the landlord can't threaten to evict you, probably has no claim against you, and they're entirely in the wrong. When about 25 days have passed since you left, and you've not received the deposit or accounting, another communication by mail or email comes next. You tell them that you challenge the deductions they've made for any of the above reasons that apply, and that the 21 days have passed, if that's applicable to your case. This is for the judge to read, so be clear, polite, orderly, and firm. You can number or bullet point the reasons, just go down the line one by one. Arrogant and stubborn as your landlord probably is, you probably won't get the dignity of a response. No matter. You're expecting that. But what you've been doing, if you follow these instructions, is setting the landlord up for the big surprise. Under Civil Code 1950.5L, the landlord additionally owes you up to twice the total amount of the security deposit as a bad faith penalty. So if you got nothing back, it is total of triple the amount. If your deposit was $3,000, he owes you $9,000. Since $10,000 is the small claims maximum, and if triple your deposit is more than $10,000, you might spring for a superior court case instead of small claims. His insurance won't cover that, so he has to hire his own lawyer and pay the money to you out of his own pocket. Now, the bad faith needs to be clear. You need to show this to the judge. So you argue. It was bad faith because the landlord holds your deposit in trust with a fiduciary duty to return any portion not lawfully claimed. It was bad faith for the landlord not telling you about the right to a preliminary inspection, which is deceit, a form of fraud, where instead of lying to you, they don't tell you what the law is in order to cheat you. It was bad faith that he didn't conduct the inspection so as to prevent you from preparing and fixing and enable their own trashing the place rant. It was bad faith because they lied about when you left. It was bad faith because they charged deductions for things that you clearly did not owe, trying to steal your money by fraud. It was bad faith because they didn't account within 21 days, as you told them, and dared you to do something about it. It was bad faith because he didn't even account for the deductions or included false charges. It was bad faith because he didn't even respond to your letter. The landlord should not be permitted to embezzle your money and defraud you like this any more than a thief should be set free if they return the item they were caught stealing. They must be punished, and that is what the law requires. This is why there's a bad faith penalty. They need to be taught a lesson so that they don't ever steal from their tenants again. In addition to the bad faith penalty, you can also sue for punitive damages, which is extra money just to punish the landlord for maliciously embezzling from you in a trust position and defrauding you, falsely claiming charges in order to steal your money. You get the point. He's a real bad guy, so the judge should make him pay you extra. He has no excuse because you wrote him that nice letter explaining in detail, and he ignored you. While you're at it, you might as well sue the landlord for everything else. Coming into your unit without a proper 24-hour notice or legal purpose is trespassing and an invasion of privacy. Failing to fix uninhabitable conditions is a breach of contract, as is charging illegal late fees. Threatening you with eviction for requesting repairs or calling inspectors is retaliation. There may be other things we can tell you about in a consultation. It's only a little more work, and if you don't sue it for it at the same time, you give up the right to do so later. When you get your judgment against the landlord, collecting is the easy part. You can call in the landlord for a judgment debtor examination to find out where all his assets are that you can take. He has to tell you or he goes to jail. You can send the sheriff to the landlord's bank to take money out of any account in his name. You can have the sheriff put the landlord's house or apartment building itself up for sale. You can have the sheriff collect the rents from the other tenants as they come due. You can have the sheriff take the landlord's car and sell it. You can garnishee the landlord's salary at work, which is embarrassing, or install a keeper in his store to tap the till, also embarrassing. Best of all, he has to pay you the extra costs involved with taking all of these extra actions on top of the judgment, which, by the way, accrues interest at 10% per year. So you see, you're not powerless to do anything. Play it smart and buy the book and collect big. Just watching the landlord's expressions as you put him through this is worth the investment. Get started.